Okay. So again, welcome everybody. My name is Pat Allman-Rode. I'm one of the co-facilitators of Third Act Lawyers, and very glad to have you with us tonight. We have a couple of stellar presenters tonight, Carrie, Jenks, and Michael Gerrard, who are going to talk to us about current and evolving climate change laws and regulations. But just in case there are some of you on tonight who don't know much about Third Act already, let me just say a little bit about the organization that we belong to. Third Act is a volunteer organization founded by Bill McKibben a couple of years ago, when I think he realized that he himself was getting a little long in the tooth and that our age cohort had a lot of potential for affecting, in particular, the things that he was concerned about and that we've become concerned about, preserving the climate and saving and restoring our fragile democracy. So those are the two things that we work on. Third Act is specifically designed for folks 60 and over. We are, as I'm sure some of you know, the largest growing demographic group in the country right now. I find this really hard to believe, so I always like to say it to everybody. The last I saw, about 10,000 people every day in the US turn 60. So we're a huge demographic bubble. As you know, we vote more regularly than lots of demographies or demographic segments. And by some estimates, our age cohort controls about 70% of the wealth in private hands in this country. So we have a lot of potential for leverage in these areas, and we would like to bring that potential to bear. So we're glad that you're here. As I said, we work on a couple of different areas, climate and democracy. And tonight, for the last webinar of the year, we're going to focus on climate. Again, we're going to hear about current and evolving climate change laws and regulations. Our first presenter is Carrie Jenks. With over 15 years of experience working in climate and environmental law, Carrie is the executive director of Harvard Law's Environmental and Energy Law Program, or the EELP. She leads the EELP team to identify legally durable strategies to support climate and environmental policies and advance clean energy development. With her legal and policy expertise in climate and environmental law, she's worked to build strategic alliances among stakeholders to advance policy solutions. Prior to EELP, Carrie was an executive vice president at MJ Bradley and Associates, where she directed power company coalitions that have played a critical role supporting and defending in court air pollution and climate regulations. Before that, Carrie was an associate at Goodwin Procter and Wilkie Farr and Gallagher. She received a JD from Georgetown University Law and a BA from Harvard. And Carrie will be followed tonight by Michael Gerrard, the founder and faculty director of the groundbreaking Sabin Center for Climate Change Law and one of the foremost environmental lawyers in the nation. Mike Gerrard is an advocate, litigator, teacher, and scholar who's pioneered cutting-edge legal tools and strategies for addressing climate change. He writes and teaches courses on environmental law, climate change law, and energy regulation. He was the chair of the faculty of Columbia University's renowned Earth Institute from 2015 to 2018. For 3 decades before joining the Columbia Law School faculty in 2009, Michael practiced law in New York, most recently as the partner in charge of the New York office of Arnold & Porter, where he remains senior counsel. As an environmental lawyer, he tried numerous cases and argued many appeals in federal and state courts and administrative tribunals. He also handled the environmental aspects of diverse transactions and development projects and provided regulatory compliance advice to an array of clients in the private and public sectors. Michael has written or edited 14 books, including Global Climate Change and U.S. Law, the first and leading work in its field. and Legal Pathways to Deep Decarbonization in the United States, co-edited with John Dernbach. He's taught courses at Yale School of Forestry and Environmental Studies, the Sorbonne, and the University of Malta, and has lectured on, I love reading this list, Michael, has lectured on environmental law in Brazil, Canada, Chile, China, Costa Rica, Denmark, France, Great Britain, India, Israel, Italy, Japan, Malta, Marshall Islands, the Netherlands, Norway, Spain, Switzerland, Taiwan, Vatican City, and throughout the United States. He has also worked with the government of the Republic of the Marshall Islands on the legal issues caused by rising sea levels that threaten the island nation. So we're very glad to have both Carrie and Michael with us here tonight. And with that, I'm going to turn it over to Carrie.
Great. Thank you so much for having me tonight. I'll just share my one second. Okay. How's that look?
Great.
All right.
Oh, Carrie, I'm sorry. Just one more housekeeping thing. Please put your questions in the chat. We'll take them at the end of the program tonight so that both Carrie and Mike have plenty of time to present. Thanks, Carrie.
Of course. So I'm going to focus on 3 rules, but first, just a little bit of background on the program that we have at Harvard. As was described, we operate like a research arm or a think tank at the law school, and we have a team of lawyers that are a part of our team, as well as law students that we're hiring to help us. I put in the in that slide some of the resources. We do a tracker, a regulatory tracker of many of the Biden administration's rules. We've got a podcast as well that digs in deep with some really interesting folks. So I put those resources there for folks. And what I thought I would do was to walk through 3 rules focused on the Environmental Protection Agency. Right now, the transportation sector is the largest source of emissions, greenhouse gas emissions, closely followed by power and industrial. So I'll talk about the status of some of the car rules and the litigation that's ongoing, speak a bit about the proposals that EPA have put out for greenhouse gas standards for the power sector. And then I'll focus a little bit on the oil and gas sector rules that the Biden administration just released this weekend. So I can't dig into details because it's a really long rule, but I'm happy to give you a sense of what we're thinking we're going to see in that rule as we dig in deep. And for each rule, I'll try to explain what Congress has done that sort of changed the baseline for these rules, talk about the agency, some of the details, and then provide a little bit of perspective of what that might mean for the courts. So starting first with Congress, as many of you I'm sure are aware, Congress passed the Inflation Reduction Act in August 2022. It's designed to spur investment in clean energy tax credits through grants and other funding mechanisms. So they're really acting as carrots. It was projected to reduce greenhouse gas emissions by about 40% from 2005 levels by 2030. But again, they're really carrots. And so they're designed to create incentives for people to act differently. But it doesn't necessarily require certain actions. What it does do, though, I think, is it changes the baseline for EPA rules, as many of the programs bring down the cost for clean energy technologies. And that really helps sort of accelerate some of these EPA rules. As I mentioned, I will talk about the cars and what they're doing for them, power sector, and then methane. One more background slide before I dig into some of these rules. I think it's important to flag one of the cases that's come out of the Supreme Court in recent years, which is West Virginia versus EPA. And in that case, the question was whether Congress authorized EPA to set a standard that accounts for measures that reduce emissions from the electric sector through either generation shifting or a cap and trade program. And generation shifting was the shifting of emissions from coal-fired power plants, higher emitting resources to, for example, renewables. And the Obama administration finalized a rule where it really based the standard on that generation shifting. And the court said no, EPA did not have the authority to set a standard based on an emissions cap for greenhouse gases based on generation shifting. So that option is off the table now for the Biden administration. It's also important, I think, to note, though, that they articulated the major question doctrine, and they employed it to conclude that EPA lacked the authority to require that generation shifting. And they announced this doctrine and articulated it clearly to say that in extraordinary cases, which the court deemed this to be, Congress doesn't use oblique or elliptical language to authorize an agency to make what it characterized a radical or fundamental change to a statutory scheme. Rather, they said that both separation of powers and principles and a practical understanding of legislative intent make us reluctant to read into it what they called an ambiguous statute to the delegation that might be lurking there. Rather, the agency has to show clear congressional authorization for that power. There's a lot of debate among legal scholars about what the major question doctrine is, how it should be limited, but that lens is going to sort of frame out how agencies, stakeholders, and the courts obviously view many of the rules that I'll talk about tonight. So shifting to light duty vehicles, I thought I would focus on the car rule. And I think it's important to look back and sort of see the history of how the agency has been doing these rules and the flip back and forth. So just to ground you, those green lines are the election lines to understand where the agency is. And there's three actors to keep in mind. First, we have California, because they have special status under the Clean Air Act to adopt and enforce their own statutory scheme. But EPA has to grant that waiver that California can request. EPA can also issue its own greenhouse gas standards for vehicles. And then NHTSA, the National Highway Transportation Safety Administration, can set fuel economy standards under the CAFE program, the Corporate Average Fuel Economy Program. So to ground you, in July 2009, EPA granted one of the waivers for California rules, starting from model year 2009. This was a waiver that CARB had originally requested in 2005, but the Bush administration had denied it. When Obama came into office, though, they granted that in 2009. Also, a fundamental piece to keep in mind is that Obama administration also made the endangerment finding that it was the greenhouse gases endangered public health and welfare, and they connected that with the cause and contribution finding to vehicles. In 2013, they granted another waiver for the Advanced Clean Car Program, and this is where California was implementing its low emission vehicle, the LEV program, as well as the ZEV program, the Zero Emission Vehicle Sales Mandate, which is the greenhouse gas standards. The Trump administration came in and that flipped. They decided to withdraw that California waiver from 2009. Then we had another election, and the Biden administration came back and they put the waiver back in place for the vehicle standards, or for California's vehicle standards. So shifting to the federal standards, we see that same back and forth. EPA issued and NHTSA issued the standards for model years 2012 to 2016. And that was projected to achieve about, if everybody complied with fuel efficiency, about 35.5 miles per gallon, just to ground you. For model years 2017 to 2025, the Obama administration standards would have achieved a 54.5 miles per gallon. But then, as you know, we had an election. The Trump administration pulled back those model years, and so they finalized a rule for model years 2021 to 2026 that really did not achieve much reductions, if any. But then we had another election, so now EPA has model year 2023 and 2026 finalized. They have finalized that rule, and I'll talk about the details for that in a minute. They've also finalized or proposed, model years 2027 and beyond. So those are the two rules that I think are important to keep in mind, and what is going to be in the courts as we speak. So this graphic just shows some of the standards. So now that we're shifting to those more stringent targets, people are talking about how much electric vehicle deployment is projected to achieve under these standards. So 17% is under the model years 2023 to 2026 standard, the final rules that we've got in place right now. And the new proposed standards are projected to achieve about 70% EV deployment. And those are just projections, but that's one way that companies could comply is that amount. But this last column shows you what's projected to happen business as usual. So even if EPA weren't to do any final rule, they're projecting by 2032 about a 40% deployment of adoption of electric vehicles. So it is suggesting that EPA's rule would drive more electrification, more transportation of EVs, but this is the projected rule and what's proposed. So shifting quickly to some of the litigation that's ongoing, in mid-September, many people refer to it as Auto Week in the DC Circuit. They had 2 days of oral argument on some of these standards related to the standards that are finalized, so model year 2023 to 2026. And there were 3 cases. The first case, Texas versus EPA, was about whether EPA finalized the standards consistent with their authority. And this is where major questions was raised again. And the question was whether EPA can set a standard that drives electrification and reflects what's happening in the market. So they were fighting over that 17% and whether that was driving electrification, driving deployment of electric vehicles, and whether EPA had that authority. So it was one of the issues before the court. In Ohio versus EPA, the question was whether California can have the special status under the Clean Air Act to set its own standards for this waiver. And then Texas versus NHTSA was focused on the fuel economy standards and the legality of that. So we're expecting decisions probably this spring, summer from the DC Circuit. At the same time, we're also expecting EPA to finalize the more stringent standards for model years 2027 and beyond. So we'll be watching to see how do these decisions about the first phase of these rules affect what EPA does, or does EPA finalize the rules? All of this is sort of tied together, because when you think about what the the transportation sector is doing, a lot of companies have ambitious targets that are suggesting they want to have a lot of electric vehicles deployed. And so the question is EPA driving this, or are the standards driving electrification? And I'm happy to answer questions as we dig into more detail, but I want to keep moving now to the power sector. So EPA has proposed standards, and what they did differently is, rather than saying the generation shifting that the Obama administration did that looked at the electric sector as a whole, rather here they've done 3 different rules. So they have rules for existing gas standards, new gas power plants, as well as existing coal-fired power plants. And they're looking at each sector separately. I won't go into all the details of all the different pieces, but I think it's important to remember that what the general principle was for the Biden administration is, if you're running a fossil fuel fired power plant and you plan to run that at base load, so a lot during the year and far into the future, those are the type of plants where it makes the most sense to install pollution control equipment on those plants. If, however, you're running less and you're really, for example, a peaker plant that is often used to support renewables, for example, then there's different standards where it's more about how can you run that plant to be most efficient when it is running. So to give you an example, for the coal-fired power plants, here, if you are running beyond 2040, then you need to meet an emission standard in 2030 that's consistent with installing CCS at 90% capture rate. If, however, you have a coal plant that's running right now, but you plan to retire it by 2040, then the emission standard is more based on co-firing with 40% natural gas. If you are planning to retire by 2035, then you have to meet an historic emission rate and achieve that capacity, a capacity factor of only about 20%. But if you plan to run and retire by 2032, so in the near term, then you need to meet your historic emission rate. So they were really trying to say by 2030, you need to decide when are you going to retire. If you are planning to retire, then you need to make less investment in that plant than if you're going to run far into the future. Again, I want to flag, though, this is a proposal, so I expect things to change as EPA goes through this comment process and understands where they want to finalize these rules in the coming year. For new gas, we saw a similar type approach. They said if you're going to build a new gas plant and you expect to run it in base load beyond 2038 or so, then you need to, by 2032, meet an emission rate that's either starting to be based on a CCS-based standard or a hydrogen-based standard. So you need to make that choice in about 2032 and have CCS installed by 2035, or blending significant amounts of hydrogen by 2038. However, if you're an intermediate plant, meaning you're running some and serving a different role in the grid, then you meet an emission rate that's about 1,000 pounds of CO2 per megawatt hour. So you could be needing to blend some hydrogen depending on the type of plant that you build. If, though, you're operating like a peaker and you're really supporting the renewables, you need to meet an emission rate that's more consistent with lower emitting fuels. For existing gas, they only proposed to regulate baseload units. So they said, similar to new gas, if you are a baseload unit, meaning you're a large unit over 300 megawatts and you're operating above a 50% capacity factor, so operating frequently, then you need to meet an emission rate that's consistent either with CCS or significant blends of hydrogen. So again, they're asking for comment on a bunch of different levels of this. They're trying to understand where are stakeholders on these issues, and really how are plants going to be operating in the future, knowing that there's all these incentives from the IRA and state incentives and customer driving renewables and nuclear and different investments in the grid. So the grid is really transitioning, and the question is, how can this rule sort of reflect the transition that is happening? Lastly, I want to talk about the oil and gas methane emissions. And full disclosure, the rule they released it on Saturday as part of COP. It's 1,690 pages, so many of us are starting to read and dig and try to figure out what the rule says. But we've been working on this rule with stakeholders since they started it. And it's a little bit different because unlike a power sector where you can understand how much fuel is going in, how much emissions are coming out of the stack, the oil and gas sector and the methane emissions are really diverse, and it's hard to know where emissions coming from. We're really getting more information from satellites and aerial surveys to understand that we've been underestimating the methane emissions and not knowing where these emissions are coming from and how best to fix them. But we're starting to see that technologies such as aerial surveys and satellites are giving us better information. That's enabling companies to understand how to operate their systems better, how to design them better, and then also getting more information in real time so people can quickly fix leaks that are happening as well. What has happened in the past few years is that just before COP 2 years ago, the US and EU announced the Global Methane Pledge, and that committed countries who signed on to it to achieve at least a 30% reduction from 2020 levels by 2030. About over 150 countries have signed on to this pledge now. From the US perspective, every time just before COP happens, EPA has taken an action, usually proposals, and now this year a final rule that sort of signaled where we're going for the oil and gas sector in the US. So that's what happened on Saturday. And I think the new rule that was just released is projected to achieve an 80% reduction from methane emissions. And it's driving a lot of emissions. It's got some interesting programs, including a super emitter program, which is using satellite information and allowing third parties to identify super emitter events, which are large emission releases. And EPA will use that information to ensure that companies are acting on that information if it wasn't a planned event or maintenance event. The other key piece is that the rule starts to set the stage for EPA to finalize a waste emission methane charge, which was authorized by the Inflation Reduction Act. And that's essentially acting as a stick. Even though I said the IRA is mostly carrots, there was one important stick, which is sort of this methane fee, where companies are going to be obligated to pay a fee based on the amount of methane emissions that they have. So this rule is designed to try to reduce those emissions, but the methane fee should be proposed by the end of the year that will start to really create an incentive again for companies to find leaks and fix them faster. This is a graphic that we just put together today. I know the type is small, but we've put it on our website, or we'll be putting it on our website. And it starts to show how these three rules that EPA is now working on interact. So the top line is the 111 rule that just came out this weekend. Subpart W is the greenhouse gas reporting rule, where they're updating the information that they're assuming emissions, how companies sort of account for their emissions, given more emissions data that we're having. And then the waste methane charge will be based on that reporting rule. So as companies better account for their emissions, they pay that fee. But then the Section 111 is supposed to incentivize companies to reduce their emissions over time, in addition to that fee. And there's exceptions as well as that 111 rule starts to get implemented. So I'm happy to take questions on how those three work together, but I think it's interesting to think through how can the agency think through how do you create incentives for companies to overcomply and reduce their emissions over time. To conclude, I think it's important to think through how these rules really build upon what's happening in the industry already. And the Inflation Reduction Act, I would argue, is a regulatory driver. If I use the analogy about carrots, you can put carrots on children's plate. The question is, like, do you get to eat? How do you encourage people to eat those carrots? So some people have said we should put hummus on the plate. And I think the regulatory drivers, EPA's rules, start to ensure that people sort of uptake these incentives that are happening from the IRA. So for cars, Many manufacturers, as I mentioned, have commitments to support the deployment of EVs that are consistent or even more ambitious than some of EPA's rules. So this transition's happening. And the question is, can the Inflation Reduction Act encourage more uptick? And can EPA's rules sort of reflect what's happening in the market to support deployment of more electrification? For the power sector, that sector is also transitioning. The IRA is providing incentives to accelerate that transition, and EPA's rule is intended to drive regulatory uncertainty for those investments. The debate that's really happening now and for EPA to finalize that rule is about timing and whether the infrastructure for transmission lines and the infrastructure that's needed for these technologies will be ready in time to support the transition that's already occurring. And then lastly, for oil and gas, as I was mentioning, the funding for technology deployment, the IRA methane fee, and the requirements for EPA to finalize the rules that I was mentioning can drive a durable regulatory approach that has the potential, I think, to really deliver important emission reductions. And then final point, to bring it back to the courts, I think there's no doubt that all of these rules will be litigated. I think all climate rules end up in the courts for one reason or another. But to the extent the agencies are designing the rule to be consistent with what industry is doing, what states are driving, what Congress is creating the incentives for, each of those drivers, I think, can help agencies design more durable rules, meaning they can be complied with, they can be enforced, and then they have a basis to be upheld by the courts. But I'll stop there. I look forward to the Q&A, and I'll turn it over to Mike.
Thanks very much, Carrie. Thanks very much, Pat, for that introduction. Let me now share my screen.
Thank you very much, Carrie.
Can you see that all right? So a lot of activity is happening in the United States and around the world on requiring companies to disclose their...
Do you want to flip it, though? I think it's the other way. We're seeing the presenter view.
Okay, let me try. There we go. How's that? So a lot of activity is happening around the United States and the world and requiring corporations to disclose the impact they're having on climate change, both quantifying their greenhouse gas emissions and what kind of pledges they're making and how they can make sure that, how people can make sure that they're meeting those pledges. So the bulk of the attention has gone to the Securities and Exchange Commission. In March of 2022, the SEC issued a very large proposed regulation on climate disclosure. It has become massively controversial. We know that the minute it goes final, or maybe the hour it goes final, it'll be challenged in multiple lawsuits in federal court. And the SEC keeps on pushing back when it's going to issue the final rule. And there are leaks that they're going to weaken the rule from the original proposal. So we don't know what's going to emerge. In Europe, the European Union has adopted the Corporate Sustainable Reporting Directive, which requires a great deal of disclosure by companies that operate in Europe, but this would be global disclosures, and I'll talk more about that. California, just in the last month, has enacted 3 laws that in many ways go beyond the SEC rule. One is called the Corporate Data Accountability Act, one is the Climate-Related Financial Risk Act, and one is called Voluntary Carbon Market Disclosures Act, and I'll talk more about those. Legislation has been introduced into the New York legislature. That would be very similar to the California laws. The federal government has issued proposed amendments to the federal acquisition regulations, which govern government contractors and would require many of them to make a lot of disclosures. The U.S. Federal Trade Commission seems to be about to issue regulations trying to cut back on greenwashing. And the U.S. Commodity Futures Trading Commission looks to be about to issue rules on use of carbon offsets. So probably the most controversial element of all of these is the treatment of Scope 3. And let me just explain that for people aren't familiar with it. So scope 1 emissions from a company are its direct emissions, the emissions that come out of its facilities, its power plants, its factories, it's the vehicles it owns. Scope 2 emissions are essentially the emissions attributable to generating the electricity that it buys from the grid. And disclosure of scope 1 and scope 2 emissions, lots of companies do that, and it's not especially controversial. But scope 3 is the supply chain emissions. It's the emissions both from what they take in. So for instance, if they're a construction company and they're buying steel and cement, the emissions that are caused by the other companies that make the steel and the cement, the emissions from the transportation of materials to the company, lots of other things that are upstream. And on the downstream part, what are the emissions from what they sell? So a automobile company, its scope 3 emissions include the emissions from the cars and trucks that it sells to customers. An oil company scope 3 emissions are from everybody who uses their fuel. And there are lots of other aspects. So there's been massive controversy about whether companies should disclose their scope 3 emissions. Another major element of controversy concerns the net zero pledges that many corporations are making. This is one set of research that shows that of a very large data set, 46% of these companies are making net zero pledges, saying that by some year, typically 2050, they're not going to have any net emissions. And most of these net zero pledges rely very heavily on offsets, on the idea that although these companies will continue to be emitting greenhouse gases, they're going to pay somebody else to reduce theirs. And this is typically paying somebody to grow a lot of trees, or to build wind and solar farms, or to do various other things. Major questions about the legitimacy of these offset pledges. Are they really going to grow the trees? How long are the trees going to last? Will they burn down? Might they have been grown anyway? Lots of other questions about offsets. So this is the other major source of controversy. So I want to compare various aspects of the proposed SEC rule and the European Union rule and the new laws out of California. So first, in terms of who's covered by these rules, the SEC rule would be issuers of US listed securities and companies that are traded in the US, even if they're not listed here. The European Union rule applies to issuers of securities listed in the European Union and to companies headquartered in the EU that have 250 employees or 250, and rather 20 million euros in assets or 40 million euros in avenue revenues, any two of the three. And also the non-EU parents of any of these companies over a certain size. California has a threshold for one law, $500 million in annual revenues, the other $1 billion in annual revenues for any company that does business in California. And it's not clear exactly how much business you have to do, but some pre-existing definitions say not very much. So a fairly modest-sized company that does business in California would have to be reporting its emissions and other things everywhere. It's not only the emissions within California. There's one estimate that the California law would cover about 75% of the Forbes 1000 companies. So it has very broad coverage. And very significantly, it applies not only to publicly traded companies, which is the limit of the SEC's jurisdiction, but also to private companies. So there's some very large private companies that haven't had to do any of this reporting. The largest two of them are Cargill and Koch Industries. Both of them have operations in California, and both would have to be making global disclosures under this. So that's who's covered. The scope 1 and 2 emissions would have to be are mandatory disclosures under the SEC and under California. In Europe, only if they're material from either a financial or impact perspective. Scope 3, the really controversial one, under the SEC, it would have to be disclosed if these emissions are potentially material to investors. A lot of uncertainty about just what does that mean, or if they've set an emission reduction target that includes scope 3 emissions. Europe, only if material from either a financial or impact perspective. And again, very importantly, California mandatory for everybody. Everybody who's reporting, who has to report, public and private companies, has to disclose their scope 3 emissions, regardless of whether it's material. Now, this could have a real impact on behavior. So let me just go back to this slide. All these companies that are selling to or buying from a company that has to report will be asked to tell that reporting company what their emissions are. Now, a lot of them will have no idea, or there are going to be sort of industry standards, standard like 10 pounds of greenhouse gases per ton of steel or whatever it is. But in any event, all this information will come in. The companies that want to be able to say that they have low scope 3 emissions are going to be pressuring their suppliers to reduce their emissions, maybe pressure their customers to reduce their emissions. All this data is going to be publicly reported, so it will allow the public to keep an eye on what companies are emitting what. It'll allow companies to be compared within a sector. What steel companies are more or less emitting per ton of steel. We know from some other disclosure laws, like those for toxic substances, that having to disclose really does have an effect on corporate behavior and on their emissions. So this scope 3 disclosure is not just a matter of putting numbers out there, but it's very consequential. Comparing these 3 regimes in other respects, all of them will require a lot of disclosure on their carbon neutrality claims, if they are making them, and what kind of use of offsets they're making. All 3 of these, in different ways, require corporations to make disclosures about how they are planning to reduce their greenhouse gas emissions, and not only to say net zero by 2050, but have a lot of interim targets along the way and specify just what they're going to do when. They also have to disclose their vulnerability to the physical impacts of climate change, how they are transitioning to cleaner energy, and many other things. The initial deadlines, the SEC rule, well, when it was proposed 2 years ago, it was going to start in 2024. We'll see what happens. The European Union rules are being phased in through 2029. The California bills as signed required scope 1 and scope 2 emissions to be disclosed starting in 2026 and scope 3 in 2027. But when Governor Newsom signed the bills, he said he was going to be looking for an amendment to give companies more time. So we don't know when that'll kick in. The auditing requirements, the SEC has limited assurance for scope 1 and 2, no auditing for scope 3. California, limited assurance and scheduling up to reasonable assurance. The European Union, alone of these 3, requires disclosure not only of greenhouse gases, but also impacts on pollution, water resources, biodiversity, affected communities, working conditions, and consumers. So lots of things. So in California, as I said, it'll go beyond the SEC, both in terms of requiring reporting by private companies as well as public, and not having a materiality threshold. But the bill told the California Air Resources Board to issue regulations by January 2025, though Governor Newsom may try to get a bill to extend that some. But there are a lot of open questions. How do these apply to affiliated corporate entities? So if a company has to disclose, what about its parent corporation? What about its subsidiaries? What about its sister companies? Are they included? We don't know that yet. Which scope 3 categories have to be disclosed? There are about 15 different scope 3 categories. Nobody discloses all of them. Which of them will have to be disclosed? How are they going to try to make these consistent with the SEC rules and the European rules so that companies aren't going crazy having to file a whole bunch of different kinds of reports with different entities? And then what scenarios have to be studied for the physical impacts of climate change? Do they have to assume 2 degrees, 3 degrees, lots of questions. And what kind of lawsuits will this face? The California rule, for reasons I can get into if people are interested, I think is less vulnerable than the SEC rule to litigation. But there probably will be some litigation, and we'll see what happens. One bill that I think is very important but has received very little attention, the California Voluntary Carbon Market Disclosures Act. As I said, a lot of these offsets are highly questionable. A lot of questions about really whether they are really happening, whether they're on top of things that would have happened anyway, can they be verified, and so forth. So in what I think is going to be a major crackdown on the voluntary offset market and voluntary carbon credits in general, is that disclosures are going to have to be made both on the supply side and the demand side. Any company that is selling offsets and any company that is using offsets to say they're going to be carbon neutral or going to reduce their emissions are going to have to make lots of disclosures about the fine-grained details of these offsets. This law takes effect next month, takes effect in January. Governor Newsom did not say he wanted that extended. And so this is going to make it much harder for companies to use these pledges, these offset pledges, in claiming net zero. Finally, as I mentioned, the federal acquisition regulations are being amended. The proposal came out in January 2022, and they require scope 1 and scope 2 disclosures by any business that does $7.5 million in federal contracts, and scope 3 by companies with more than 50 million in federal contracts, which is not a lot by federal contracting standards. And so, and this also applies to private as well as public companies. And again, there's no materiality threshold. So this little notice regulation is going to get to a lot of companies. And unlike all of these other disclosure rules that are just disclosure, the federal acquisition regulation proposal would require companies that have at least $50 million in government contracts to come up with science-based targets for how they're going to reduce their emissions. They don't really have to disclose them, but they have to show how they're going to reduce them. So as I said, there are bills pending in the New York State Legislature that are very similar to the California bill. The Federal Trade Commission will be coming out shortly, we think, with new rules attacking greenwashing, attacking all kinds of false environmental claims. The U.S. Commodity Futures Trading Commission is coming out with its own rules on voluntary carbon offsets. And just in September, negotiators for the European Union and the European Council reached agreement on the kinds of disclosures that many different kinds of companies are going to have to make about their environmental performance, not only on climate change. So these rules have to go through a lot more process within Europe, but something like this is coming. So the bottom line is that regardless of what happens with the SEC rules, most big companies around the world are going to have to be disclosing not only their scope 1 and scope 2, but also their scope 3 emissions. And they're going to have to be a lot more careful about their claims of carbon offsets and carbon neutrality and so forth. That we have lots of different jurisdictions that are going to try to capture that. And most big companies are going to be subject to at least one and probably more of these disclosure regimes.
Well, thank you very much, Michael. That's it.
That's it. That's it.
Okay, we have a couple of questions in the chat, and I have a question or two myself, but just before I forget it, it goes right back to maybe one of the last things you were talking about. You mentioned monetary, dollar limits, thresholds actually, for companies that would be affected by the changes in the FAR. I think it was 7.5 million for scopes 1 and 2 and 50 for scope 3.
That's
Is
right.
that contract in force in that particular year, or how is that actually measured?
Right. That would be the annual revenues that they receive that year.
I see. That's a very small amount for some of these companies.
Right.
Yeah, so that would really sweep in a lot.
Right.
Okay, let me spotlight Carrie with you because some of these questions will go to both of you. Okay. The first one I want to give to both of you is a very fundamental question from Jack Hammond. It may be a little more for a scientist than for a lawyer, but let's see what you do with it. Jack says, in general, can companies measure their emissions reliably? And if so, how can that be monitored? So, all of this relies on measurement. Can we actually do it in a way that makes it make sense?
Well, lots of companies have been measuring their direct emissions. In 2010, the EPA greenhouse gas reporting rule came into effect. And so most big companies, most industrial companies anyway, have been monitoring their direct emissions for years. Some emissions are more difficult to measure. Obviously, from the agricultural sector, it's much tougher, but from the forestry sector, but there are lots of methodologies and more methodologies are being developed. So yes, measurement is possible. For some kinds of emissions, it's more precise than for others. But there are certainly going to be numbers out there and methodologies to adopt them.
Okay.
Carrie, anything to add?
No, I think the one thing that we've been working a lot is the methane emissions, and there are definitely companies have been reporting, as Mike was saying, to EPA based on emission factors and consistent ways of measuring their emissions. I think what we're seeing though is that their reporting emissions are here, and as satellites are measuring them, we're seeing them here, and so we're trying to reconcile that, and that's what we're seeing happen right at this point.
Yeah, I think that goes to the second part of his question. How can that reporting be monitored? How can it be verified, I guess, is another way of saying that.
Exactly. Let me just say, I think what Carrie said about the satellites is extremely important, that we're seeing this new, I don't know if I call it a fleet yet, but there are a bunch of satellites out there that are coming up with very geographically specific measurements of where the emissions are coming from, and they can zoom in. And if they see a factory where the emissions that they're measuring from space are a lot more than the emissions that the company is reporting, then obviously action is going to be taken. So I think it's going to be much harder to hide emissions than it had been in the past.
Right. Right. Thank you. Thank you both. This question is from Evan George, and it's directed first to Carrie, and Michael, you may have some comments too. Evan asked, Ray, methane rules allowing third parties to report leaks or emissions. What do oil and gas companies say about this, and what might challenges over this look like? Do we know how EPA and other government agencies will verify third parties? So a related question to what we were just talking about.
Yeah, so this is part of the super emitter program that EPA just finalized. And there they are allowing either satellites or aerial surveys, those companies that have them, or NGOs or philanthropy that might have satellites launched, as Mike was saying, they can be certified. EPA will go through a process to certify them so that companies know what type of information they have to get, how fast they have to process the information, how specific they have to get in terms of identifying the source specifically. But there is a process by which those certified third parties can give that information to EPA, and then EPA can notify the company and the public that this event has happened. And the company is based on its assessment of whether it was an emission event that was a violation. They then have to fix that violation if it was a violation. Some of them are maintenance activities, though. They're planned release events that are legal, and that's there's a process for companies to also say, this happened and we knew it was happening and it was all legal. So to answer the first part of the question, what do oil and gas companies think about it? I think it's important to remember, like, EDF is already doing this. Environmental Defense Fund is putting out information. So as satellites are becoming used, anyone can put up a website and give information. This is a program to try to, I would argue, give a little bit more credibility and process to certify these technologies. EPA is going to say, we're going to look at this information. And then it is creating a regulatory obligation if there is a violation for those companies to fix it. So I think oil and gas companies understand that this, most companies want to know if they've got something that they didn't know was happening. But they also want to make sure that they can have a process to tell investors and the public that some of these releases are planned and legal. And so they're trying to balance that type of information on how do we educate what's possible, and how do they get information fast to act, because they're intermittent. So just because a satellite found it 10 days ago doesn't mean it's still happening.
Right.
So they also want to be able to get the information they can act on.
Right.
So it's a mixed bag.
Do you expect EPA or any of the other agencies to have sort of a list of maybe approved third-party vendors that a company can go to and say, this guy, verified my emissions numbers, and so therefore you should accept them, EPA?
So this is a rule that I think they've really tried to lean into these advanced technologies, where they had to design a regulation which is designed to be slow and deliberate. Regulations usually take about 2 years from proposal to final if they're done well and fast. And these technologies are advancing so fast. So they've got what they've called a matrix, where they've said, we think the best system is going out with a camera and looking at all these different potential leaks. But if you want to use an advanced technology, meaning aerial surveys, continuous emission monitors, or satellites, if it meets the criteria and detection, then you can use these at different frequencies. So they're trying to lean in to say, not lock in the technologies we have today, but allow advanced technologies to be used if they get certified, like you said. So they are going to set up a process whereby companies can use them to comply with various regulations, or they can be part of this sort of super emitter program as well. But EPA is going to serve a role to say, yes, you've tested the technology and it meets the specifications, and therefore you can use it in this way.
Yeah.
And all these emissions are somebody's scope 1 emissions. And so as scope 1 emissions, they're going to have to be reported under the SEC rule and the California rule and maybe the European rule. And the SEC rule is calling for limited assurance for the first couple of years, and then reasonable assurance after that. And reasonable assurance is a fairly advanced auditing method. And so they won't necessarily be relying on EPA protocols, but they're going to have somebody really certify that the numbers are as good as they can get. And the California rule also scales up everything for reasonable assurance. So in addition to the EPA protocols, there are going to be these outside independent audits that have to be done of these emission reports.
Okay. Well, thank you. And speaking of the California rule, Mike, Will Carroll asks, what mechanisms will be available to enforce the California disclosure law for voluntary carbon offsets?
So under the law, companies are subject to penalties of up to $2,500 per day, up to a maximum of $500,000. But it also provides that the state attorney general's office can take action, and you can have actions by local district attorneys and others. So there are various legal mechanisms available to go after companies that aren't making the disclosures. There's also the possibility of fraud claims against companies that are making net zero claims, but that aren't making the necessary disclosures.
There are a number of questions in the chat that sort of go along with the one I wanted to ask. I think they can kind of be swept under this one rubric, and this is definitely for both of you. How can we, and both Third Act lawyers, Third Act as a whole, and just, you know, the general Joe and Joanne citizen, how can we be most useful here? What places should we be trying to apply leverage? What places should we be trying to apply pressure? What lawsuits should we bring? Who should we picket? You know, that kind of thing. What can we do?
Well, let me mention two things that the Sabin Center for Climate Change Law at Columbia has, where we are actively looking for volunteer lawyers. One is the Renewable Energy Legal Defense Initiative, which provides pro bono legal assistance to community groups and others that want wind and solar and so forth that are facing local opposition. We need pro bono lawyers to help with that. And we have a project called Model Laws for Deep Decarbonization, where we're drafting mostly state and local model laws based on our book, Legal Pathways to Deep Decarbonization. So anybody who might be interested in working on either of those, please contact me at Columbia, and we'd be happy to work with you.
Thank you. Carrie, any thoughts?
Yeah, I think those are good. I think tracking and understanding what rules are happening, why they're happening. I think also thinking about states. I think a lot of federal laws are based on states. So to the extent you're working in the states as well, I think that's equally important, because the federal rules always need good examples. And so whether you're at a company investing in these technologies, or you're at a state or in a state that's sort of driving this regulatory regime and these investments, I think that's equally important to think through, because it flows up to the federal government.
Yeah.
And I'll just say that I know that that one of Third Act's other activities is on democracy protection, and the importance of that cannot be overstated. That who wins the next election makes all the difference in the world.
Right. I, for one, am getting very tired of each election being the most crucial election in my lifetime, but I think that's just the world we're in now. Final thoughts from either or both of you?
Well, I think that the Biden administration is doing an enormous amount. It's quite remarkable that, you know, the Inflation Reduction Act and the Bipartisan Infrastructure Act and all the regulations they're coming out with, but the I think that they're doing about all they can given the card that they're dealt in view of what's happening in Congress. But most of that is in peril if the election goes the wrong way. And so it really does. And now, not all of it. A lot of the technological development is happening, and so a lot of things will happen. But it's really a fundamental danger to what happens with the climate and so many other things.
Yeah, I think sometimes people ask, why do we need regulation if we've got the companies making investments, and Inflation Reduction Act gave all these incentives? What's the point of regulation? But I think you need that stick and that backstop to make sure that we keep making that progress. So I think that's a key piece in mind, that I think regulation gives companies investment certainty too, and I think that's equally important.
Okay. Well, I want to thank you both again for taking the time to speak with us tonight, and for all the work that you're doing. Really appreciate the opportunity to hear from you. We will definitely be in touch. Michael, I know that Sabin Center presented on those two programs in our launch event, and I think we've had some contact with you since then. But Will Carroll will follow up. He's our pro bono coordinator for Third Act Lawyers. And let me just check this last message that came into the chat. Okay. So once again, I'm Pat Almanrode. I'm one of the co-facilitators of Third Act Lawyers, and this is our last webinar event for the year, but stay tuned. We'll do more next year. Let's see. We will be distributing the slides and the recording. And if you are not already a member of Third Act or of Third Act Lawyers, please get in touch with us. The main website is thirdact.org, and there's a page on there for Third Act lawyers, and we welcome anybody over 60 who has either a current or retired law degree, and we'd be happy to have you along. So thanks very much again, everybody, and have a good evening.
Thank you.
Thanks.